Good evening. Thank you for all of you who have joined this evening for our third program on issues relating to criminal justice. And tonight's program is Criminal Justice and the Islamic Legal Tradition. My name is Syed Atif Rizwan, and I'm Assistant Professor of Islamic and Interreligious Studies and the Director of the Catholic Muslim Studies program. To begin with, I'd like to thank the Bernadine Center, Peter Cunningham and Steve Millies for their support, especially when it comes to logistics and trying to get everything to smoothly. It would not be possible without them too, so I thank you so much. I also like to thank Colleen Urbaniak in the marketing department for helping us to get the word out, and so all of you can join today as attendees. Now, in terms of the program, what I'd like to do is first give an overview of what is the Sharia and what is Islamic law as part of the Islamic legal tradition. This will help to situate our two esteemed panelists. Thereafter, we will have each panel speak for about 50 to 20 minutes. While they're speaking, you will be able to submit questions, and I strongly encourage you to submit questions through the Q&A function. The chat function has been disabled, but the Q&A function is working. And so for that reason, please submit questions through there. So with that, I'd like to begin real quickly with talking with everybody and giving them a quick overview of the Sharia. Sharia and Islamic law. So what is the Sharia? Well, in the Quran, it says, now that we have put you, Muhammad, on a clear path, the Sharia, follow it. Do not follow the desires of those who lack knowledge. This is the only time in the Quran the term Sharia appears. Moreover, what you can see from this is that it does not mean any sort of law or positive law. So when one thinks about the totality of the Quran, when one reads the totality of the Quran, in that regard, the Sharia is actually a reference to universal and natural laws of goodness. It's the ideal. It's objectively perfect divine truths. And therefore, because they are with the divine, they are directly inaccessible to human beings. So that is what the Sharia is. It's the divine law. So what is Islamic law as part of the Islamic legal tradition? It represents the interpretive legal rulings. It encompasses a search for the divine will. To put it shortly, Islamic law is the interpretive expression of the Sharia. So in this flowchart, the Sharia, it is ideal, it's infallible, it resides with God. Muslim legal authorities employ interpretive processes, different jurisprudential methodologies to develop Islamic laws. They use things like the Quran, the prophetic practice, the practices of the early Muslim community, as well as their own socio-historical context. And in consideration of all these things, develop what would be deemed positive laws, and in this regard, Islamic laws. Now, because the tradition is an interpretive tradition of the Sharia, there can be different legal rulings. And so you can have one single case, and for example, you can have three different rulings to that case. So what does that mean? That means that three different legal rulings could all have equal validity. So there's a diversity and a malleability that emerges based on the interpretive exercise. Let me give you a quick example of an ideal and then the interpretation of a law, of a Sharia and then the positive law itself. Here's a Sharia. We hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. This is an ideal. It is suggesting that everyone is created equal and have the right to life, liberty, and the pursuit of happiness. Yet in 1776, one white male equaled 3/5 black male for voting purposes, and women could not vote. And it was in 1954, through the Brown versus Board of Education case, that desegregation of schools actually took place. And then it was finally in 1965 that African Americans were allowed to vote. So you went from an ideal which suggested that everybody is treated equal and has certain inalienable rights, yet you have laws that were patently racist. Why is that? Because during the interpretive process, socio-historical context informed the laws, and over time they changed. And this is the same way in which, when one looks at the Islamic legal tradition, you may have one ideal and then you have actual laws that are interpreted and expressed based on socio-historical context. So as a final schematic, the Sharia is infallible, and Muslim legal authorities, they employ interpretive processes to deduce laws, which are fallible. And what Muslim legal authorities have done is that they have created two categories as main expressions of the Sharia: rituals, which include prayer, fasting, and almsgiving, and interpersonal, which includes things like contract law, family law, and the discussion for tonight, criminal law. So with that, I would like to introduce our first panelist, Professor Susan Haskell. She's the former assistant professor of law at Duquesne University School of Law, and her areas of interest include commercial, contract, comparative, international, and Islamic law. And I'm especially honored to have her tonight because she has an article that's titled "Restorative Justice in Islam: Should Qisas be Considered a Form of Restorative Justice?" It has partly informed the inspiration that I've had to pursue this panel, as well as some of my own recent work on the intersection of the Islamic legal tradition and criminal justice reform. Professor Haskell also is working with corporations on diversity training and methods and presentations that focus on exposing unconscious stereotypes, fundamental fairness, justice, and empathy. And lastly, and certainly not least, she's also working on projects that include the examination of the radicalization of white male prisoners in the US. So with that, I'd like to turn it over to Professor Haskell.
Thank you so much, Professor Rizwan. I'm honored to be here, and it's so good to see my colleagues. I'm going to be talking about the law of theft, and I'm going to just now share my PowerPoint presentation with you. All right, so this is the title of my talk: Theft in Islamic Law, Comparative Examination of a Justified Defense in a Civil Society. I chose theft because there is a defense in Islamic law for a charge of theft. And as we'll see, the definition of the crime theft, sarika, is not exactly the same as what we would usually think about it, but the defense is a defense of poverty. If somebody's forced to steal in order to feed their family, then that is a defense to the imposition of the Had penalty. So I believe that this is an important crime to look at in the context of comparative law, because it intertwines ideas of social justice and also universal truths about the relationship between morality, justice, and the criminal law. So that brings us to the more general topic of what is the purpose of criminal law? Is it for social control? I mean, that is definitely a purpose. We don't want everyone following their own rules and doing whatever they deem appropriate, especially if they're hurting other people or society. Retribution. A lot of people believe that one of the purposes of criminal law is to punish the offender, which also goes into the idea of revenge. And then there's also an idea of rehabilitation. So philosophers and criminologists and sociologists have been discussing these purposes of the criminal law for a millennia, for a very long time. And they've come up with the various responses to this particular question. However, I'm interested in a deeper level: justice. What is justice? All legal systems strive to achieve this concept of justice, and it's cross-cultural. There's an idea of the way things should work in a balanced and fair universe in a free society. But what is justice? Well, people have been trying to figure out what they mean by justice for a very long time. I just got this very simple definition out of Merriam-Webster's dictionary: the process or result of using laws to fairly judge people accused of crimes. Well, that packs a lot into one little sentence, so I think we'll have to try to break it down a little bit. So if we have justice, what is it based on? I think it would have to be based on some kind of a shared idea of morality. So what is morality? I think that it has to do with what we should do as good people living in a fair and free and just society, as opposed to what a crime, whereas the criminal law is what you are not allowed to do. So ideally, our criminal law system would put these two concepts together and come out with something, that would be considered just in almost all cases. So what is the application of justice and morality to criminal law and punishment? Well, I think that there can be gaps, and that's what this talk is really about when it comes to the law of theft. There can be a gap between what we consider just and what we consider moral when it comes to the imposition of criminal penalties. And that's what we have defenses for in criminal law usually. They're excuses, basically. They say, you've done all of the things that constitute a crime. However, we as a society are not going to punish you for that because you have a good excuse. You don't have the criminal intent. So in criminal law, a crime is considered an offense against the state that is punishable. It has a mens rea. There's a mental aspect of it. It can be like the intent or knowledge, etc. Not necessarily motive, but there's a mental aspect. You have to have a guilty mind. And then there's the act itself. So you have to have the right state of mind to be charged with the crime. You also have to do the act, and then there has to be a result. Now, most crimes are codified. As a professor was saying a little while ago, the Sharia Islamic law comes from a system that was not originally codified, but now is in most countries. So the parts of the crime are called elements of the crime. So those are the things that the prosecutor has the burden of proof on. They have to prove all of these things. So here's this Islamic crime of theft, basically, and I'm going to use the little air quotes because it doesn't really match up with the category of what we would consider theft in the United States. It's analogous, though. It's what's called a Haskell, which is a crime against God. It is not a crime against a person, like a personal crime, nor is it a crime against society at all. It's in a different category. So they categorize their crimes in this different way. So because it is considered a fundamental crime, there's a harsh penalty that could be applied if all the elements are met, which most of you have probably heard of, amputation. However, it's very difficult to get there. The original source for this, one of them, comes from the Quran, which is, the basic fundamental source. And there's a verse that says, as to the thief, male or female, cut off his hands or his or her hands, a punishment by the way of example from Allah for their crimes. And Allah is the exalted, powerful of wisdom. And then the next part of that says, but if the thief repents after his crime and amends his conduct, Allah turneth to him in forgiveness. For Allah is oft forgiving and most merciful. So as you can see just from this, if a person repents, then that harsh penalty would not be applied, but it gets even more complicated because there are so many elements of Sarika, and these are developed from that verse by scholars. And, over many, many hundreds of years, these things have been developed and are now codified in some states. So the first thing is that it has to be private property. It's a personal property. It has to be a taking from a non-related person. You can't own the object. There's no semblance of having a right to ownership, so it can't even arguably be something that you have a right to use or some kind of right of ownership. And no lawful possession, meaning that somebody hasn't loaned it to you or something like that. It must actually be removed. But wait, there's more. Okay, what happened to my slide? Here we go. So it's a kind of theft that has to be done by stealth, stealthy nature. You can't just run up and grab something out of somebody's mailbox or go looting and have it be considered this particular form of theft. And there's a minimum value. You can't be convicted of this by stealing a lollipop or something. And of course, the mens rea, the criminal intent, the mind part of the crime is that you have to know all these things. And then if these elements are not met, it doesn't mean that you get off scot-free. It just means that, it's a different kind of crime. It's like a lesser included type of offense, and the had penalty will not be imposed. Okay, speeding up here. These are some of the defenses. So even if all of those elements are met, these are excuses that if you can prove that you were insane or a minor, et cetera, you will not have that penalty imposed. Again, you might have to pay restitution or something, but that penalty will not be imposed. And then this is what I've highlighted here. I'm not sure if you can see it very well, that the thief has not been found to steal out of hunger. And that's the defense that I'm interested in here, because I think it really does show the connection between morality, justice, and the law, if it were to be imposed. Okay, so back to morality, justice, and criminal punishment. We do believe that a person should be morally culpable. We have a lot of those same defenses in American law: insanity, minority, et cetera. So in order to impose a criminal penalty on somebody, they have to be in a position to be morally culpable. So in the US, there's no defense to the crime of theft regarding the poverty status of the accused. However, this has not gone unnoticed in the literature. There have been a few studies about how prosecutors and judges deal with a situation where somebody is homeless, they're starving, and they steal. So prosecutors have some discretion, and a lot of times they won't actually charge them with that crime or charge them with a lesser crime. Judges can be persuaded to be lenient, but that usually happens in the sentencing phase. It's not an actual defense to the crime. Juries can, in fact, refuse to convict, which is very rare. Something else that has been written about and comes up is like, isn't this just a defense of necessity? Saying, okay, I would have to push somebody out of the way if a train was going to come hit them and they wanted to, charge you with assault. Obviously, you wouldn't be able to do that. So unfortunately, the defense of necessity has not been widely accepted, and it's not codified anywhere. So all of this is sort of happening behind the scenes in the criminal justice system, at least for now. So morality and criminality, back to that, there's a gap that I've just described between the positive law of theft in the US and moral culpability of theft. If somebody is actually starving and their children are starving, and there is no way they can go and get food for their children, I don't think anybody would think that they are terribly morally culpable for going to the supermarket and stealing, for example, a loaf of bread. So unfortunately, though, this motive is not considered. As I said, motive is no excuse for the crime of theft, even when it's happens in the context of extreme poverty. However, under Islamic law, Sharia, the gap has been filled when it comes to a motive for stealing for bread based on poverty. But how do they work that out? They don't just say it. Okay, it's the difference between our law, a US law, and Islamic law in general. This is a broad generalization, is that Islamic law, criminal law, is based on a moral code. There's not just the legal code, the moral code and the legal code actually overlaps. And I'm using the word code sort of loosely here. So we do try to align our morality with our criminal law, but it doesn't always line up perfectly. So when there's a conflict between the rights of individuals or society as a whole, some scholars rely on the underlying principles of Sharia to weigh and balance these rights and duties. So how do we do this? Well, scholars have taken a step back and looked at the underlying principles and made lists of these things. And they have come up with these 5 essentials. What is the Sharia supposed to bring us, the Islamic law, the Sharia? First, it's to protect religion, the faith, to protect life, because that's a value, to protect intellect and intellectual pursuits, lineage, your family lineage, and property. Property is right up there. And US law tends to emphasize the protection of property quite a bit. But what happens when these 2 of these essentials come into conflict? Life versus property. When we weigh and balance the right of the owner to this property that has been stolen, whatever, with the necessity of sharing to prevent death by starvation, then the property rights of the owner falls short. It's not like you would lose your right to that property, but you have a social and individual duty as a member of society to not let people just starve on the street. So here's another example, hoarding during a famine. It would be immoral for a person who owns a lot of foodstuffs to lock those supplies within the house and simply just keep them for themselves when there are people on the brink of starvation and they come and request a portion of the food. Then the owner must share that food. So again, you have the juxtaposition of the value of life versus property, and life wins out. So the defense of poverty to a charge of sedition is based on the ideals of social justice. Society has a responsibility to ensure that no one starves to death. And I think that we could agree that Americans mostly agree with that sentiment, but it's not formally codified anywhere. If a person has stolen out of this, because it's a positive right as opposed to a negative right, which is a whole other discussion, but if a person has stolen out of necessity, then the idea is not only does an individual have the responsibility to share, but society itself has a responsibility to share and make sure that society itself is not creating a situation where people are in that much of a desperate strait that they would breach somebody else's right to property in order to survive. So in conclusion, I believe that the defense of poverty for a charge of sedition is founded in Islamic law, but is compatible with the ideas of fairness, justice, and morality in US law. And we should consider more formally adopting this defense, the defense of poverty, extreme poverty, for a charge of theft under US law, as long as there are those in the US that cannot meet their basic needs and having gone through this pandemic and all kinds of different economic turndowns and not having the social services that other countries might have. I think that this is a relevant topic. And also there is a long tradition in Islamic law dealing with these same issues. So being a comparativist, I do like to find inspiration from other legal systems. That's kind of the beauty of doing comparative law. It makes you think outside of your own legal system and draw inspiration from that. So that is the conclusion of my talk, and I hope there will be some good questions afterwards.
Thank you so much, Professor Haskell. I really appreciate it. And we do have some questions coming in, and so we'll wait for the Q&A later to address them. Now I'd like to introduce to you Professor Haider al-Hamoudi. He's professor of law and vice dean of the University of Pittsburgh School of Law. Professor Hamoudi's scholarship focuses on Middle Eastern and Islamic law, and he's internationally recognized as a leading scholar in the field and has co-authored a casebook on Islamic law entitled Islamic Law in Modern Courts, as well as a nutshell on Islamic law. Professor Hamoudi spent most of 2009 in Baghdad advising the constitutional amendments to the Iraq Constitution deemed necessary for Iraqi national reconciliation on behalf of the United States Embassy in Baghdad. He's also the editor-in-chief of Arab Law Quarterly, which is a journal dealing with matters of Arab law in the English language. Professor Hamoudi's most recent work looks at the three primary forms of legal order in the Iraqi nation state: tribal law, Islamic law, and state law, and attempts to explain how they interact with one another to organize commercial and other private law activity throughout the state. So it is my absolute honor to give the floor over now to Professor Hamoudi.
Thank you, Sayed. That is very kind, and I appreciate the kind words and the very kind and warm introduction. Let me see if I can share here. I believe I can. Okay. Okay, great. So what I am going to talk about, it is a paper that I have been writing for some period of time, and I suppose it is my latest work rather than the one that Sayed identified. But it really deals with another one of the scriptural crimes, the hudud. Susan had talked about theft as being one, and this one deals with banditry, and I do take it from a comparative perspective as well. And the reason I was really interested in this subject is because banditry or ḥirāba, it is really created within Islamic law as the type of crime that sort of it's a threat to public order. It's some sort of public disorder, and I was interested in it because a lot of my works deals with Shiism and Shia jurisprudence, and Shiism is traditionally very, very suspicious of the state. And so I thought, again, as a comparatist, looking at different issues as they arise within the United States, wouldn't it be interesting to sort of take a comparative look at another system and see how those who are very, very skeptical of state authority, let's just say they don't like the police very much at all, at the same time, how do they deal with threats to public order? That is to say, they don't believe in, chaos and public disorder, and what is the balance that they create, and how do they try to create neutral criteria to distinguish between legitimate dissent and calls for, let's just say, reform or change or whatever, and concerns that the state will seek to suppress those on the one hand, with the desire to make sure that there is a public order, that is to say, with the desire to make sure that there is some control over those who would really threaten the very essence of the public order on the other. Obviously, any comparativist will tell you, I think a lot of times our work is characterized, given a caricature of this idea that somehow you take some doctrine from some other system and you sort of plop it into someone else's, and wouldn't that be great? And that would be a very bad idea, and that's, as I say, as a caricature, it's highly reductive. I think what the beauty of comparative law is that one looks at a very different system and can develop ideas and can think about potential ways in which some of those ideas might shed light on some of the biases, assumptions within one's own system, and then give those folks the opportunity to sort of examine. As you can see, my daughter has decided right now, Connie, I really have to talk. Has to, and the ways in which the balance can be struck between these two. When I say compare, and if I mean, one can try to sort of figure out that balance in the United States context or in a different context by trying to apply an Islamic law context. Can learn from an Islamic law context. Again, I apologize for that intrusion. My daughter is extremely adept at finding a way past the 7 different locked doors that I thought I had placed in place. So anyway, moving forward here, I want to break the talk into 3 different time periods that I think hopefully should be helpful. In terms of trying to identify where, or 3 different sort of sections in order to try to identify ways in which this could be helpful. And the first is to understand the nature of Shiism and where the state skepticism comes in the first place. The second is to give a little bit of background, not quite as extensive as Susan's was on theft, but at least understanding what this banditry scriptural crime is all about in the Shia texts, and then ways in which we can sort of imagine takeaways that can exist for our time. So first, just to understand what it is about the Shia that sort of make them very skeptical of the state. I think a lot of folks understand Shiism, to the extent they understand anything at all about Islam, the Shia-Sunni split, as having to do with successorship after the death of the Prophet Muhammad. While that's true, that's highly reduced, let's say, and because that sort of suggests that the issue is political, who's in control, and it's really more theological. Because all those people are gone anyway. And it's really a question of whether or not following the Prophet Muhammad, there was the idea of the institutionalization of the continuation of the Prophet's authority through the institutionalization of something known as the imamate. If I have to make a very rough analogy, Shiism understood that in the same way that, you're Peter and on this rock, the idea is that Ali, the son-in-law of the Prophet Muhammad, is the heir, the commander of the faithful, infallible. There's a doctrine of infallibility, and an imam, divinely inspired, not a prophet, doesn't receive a book, the angel Gabriel doesn't come and recite him things, but at the same time he has a divine inspiration, infallible, and then a series of male lineal descendants after him. So the idea, the analogy to the Catholic Protestant split is highly imperfect, because after the 12th male lineal descendant, he goes into hiding, the Mahdi, and disappears, right? And he is currently in occultation and will return at the end times to reestablish justice. Combining this idea of waiting for the Mahdi with the idea that most temporal authority, the Shia were the outliers. The major empires within Islam were largely Sunni, the Ottoman, the Umayyad, the Abbasid, and certainly following the death of the Prophet Muhammad, the institution of the caliphate was a Sunni institution. The word caliph or caliphate within Shia Islam is regarded very negatively. And so there was a certain marginalization of the Shia, and this view that the imams were marginalized, were oppressed, and temporal political authority was almost per se illegitimate. Well, pretty much per se illegitimate, in the sense that it wasn't the imam running the state, so whoever was running it shouldn't have been running it. Now, there is a bifurcation, even within Sunni Islam, between those who decide what the law is, independent jurists who live outside of the temptations of the profane world, the dunya. I mean, they live in it, but I mean, obviously they isolate themselves from it and read the texts and try to understand God's will. The idealized notion of the Sharia, they undertake the effort to do the best they can in the way that Sayed was describing earlier. And then political authority of the caliphs and the power and that sort of thing. But Shiism takes this to a much stronger extreme. I mean, the idea of public law, the relationship of the state to the people, or the state to its citizens or its subjects, as the case may be, is completely, well, is largely absent within Shia texts, because there's just this idea of whoever it is, if it's not the imam, the state is merely an epiphenomenon, and all we're doing is waiting for the Mahdi to come back. We'll stay alienated from it. It's there. I mean, so is alcohol, and so is whatever, and we should do our best to avoid these sorts of things. But it's something to avoid. Now, again, that has to be qualified a little bit. There were Shia empires. It's not entirely true that this, theoretical this theoretical inclination to dismiss authority entirely existed, in that kind of perfect vein forever. But at the same time, it did exist for some significant, lengthy periods of time, and it certainly controlled much of the jurisprudence. So, at the very least, even if the account is not quite as extreme as I make it, and we scholars will have endless debates about this. What about what the second more, and have these endless sort of debates? It's fair to say that the Shia jurists, taking their cue from the Shia imams, right, who rejected the caliphate and most of the temporal authorities that were Sunni dominated, took a very dim view of the state, right? So you have these jurists, and they take a very dim view of the state, and yet you have this scriptural crime that is anti-public disorder. So let's take a little bit of a look at the public, at that element, now that we sort of understand sort of where Shiism comes from, sort of the marginalized, the outsiders, the folks who don't really like the state particularly much, and understand what the origins of the ḥirāba, the banditry, if you will, scriptural crime is all about. This is the Quranic verse. Obviously, it states it in very strong terms as to what ḥirāba is, waging war against God and his messengers, striving to cause corruption, and then provides a series of punishments, exile, execution, and then even cross amputation and crucifixion. I mean, it's an extremely negative view. And as you can see, disgrace in this world, great punishment in the hereafter. There's nothing not very kind about this. I do need to make clear, because the phrase is wage war against Allah and his messenger, as God is his messenger. This is not about the law of war or the just war doctrine. There's an entire separate body of law that deals with that. ḥirāba just has nothing to do with that, because there's war against God and his messenger and strive upon earth to cause corruption, right? There's this idea that this is not some enemy non-Muslim army or whatever that's meeting on a battle, entirely different world. And in fact, the rules of jus in bello are far different in terms of how to deal with prisoners of war and the like. It's just a different universe. What we're talking about here really is bandits. You could think of them as pirates. The classic example of what this was meant to cover was, imagine, again, we're thinking of the city-states of Mecca and Medina. You're thinking of Saudi Arabia, largely desert, city-states in between, city-states, and in between them, open road, right? And that's where bandits hang out, right? And frighten people, cause disorder, threaten, steal, et cetera, et cetera. And so there's any number of things, kill, I mean, assaults, rape. I mean, all of those things are mentioned as in connection with these, in connection with these sorts of folks. And so that's the cause of the stridency of this. But what it really is, as I say, what really becomes interesting is, well, how do the jurists try to address this question when they are so suspicious of the state, to suggest that these folks who are, crossing the line, right, deserve these kinds of strict punishments? And how do we draw the line, right, in a neutral fashion between those who are really crossing those lines, while at the same time not allowing the state to just use this as some pretext to say, well, you guys are causing war against God and his messenger, and we have to engage in one of these punishments. And so a series of questions start to arise within the Shi'i texts as they're dealing with this question. Well, what does it mean to cause corruption, right? We certainly don't want that to be understood to be too broad, right? Because that could create difficulties. What kind of intent do you need in terms of this sort of causing of corruption? Does it matter where it is? I just mentioned that the classic example again is the bandit on the open road, but is that all we're talking about? What about the pirate in the sea, right? Isn't that sort of the same thing? All right, what if they're in a city, right, and they're engaged in these sorts of acts? Does it matter who they are, right? The identity of the perpetrator, and how clear does the threat have to be? How threatening does it have to be? And that really deals with the question of inchoate crimes that American law is rather big on, attempt and the like. And so here is the conclusion that ultimately Shi'i jurists reached in about the 13th century, and the debates continued long after the 13th century. So I don't want to make it sound like sort of came to an end here. At the same time, this reflects the broad consensus, and I'll give you I'll give you a chance to read it here. But you could sort of see the muharib, that's the person who is guilty of ḥirāba, and it provides the elements: draws a weapon, frighten people, and that it is relatively broad in terms of location: land, ocean, day, night, city, elsewhere. Broad on people in the sense of not people necessarily on whom you normally cast suspicion, so long as they're intending to frighten. Men certainly, women certainly, and the only real question that is being drawn here is weak in creating fear, and not against someone who watches out, is their watch person, and not someone who's offering aid and comfort to them, right? It's only those folks. And so I'm going to give you sort of the takeaways from that section of the 13th century text. But one of the things that, and this is the cause corruption bright line test, right, for the Shi'i jurists, again, given their skepticism of the state, I need to see a weapon. Draws a weapon is the statement that's made. Now, when you get to later Shi'i texts, as late as when it gets to like the 19th century, they start to say carry the weapon. And I think I'm doing some research on this, and it'll be in the paper. It seems to me that a lot of what animates their concern is in the earlier days, the weapon was the sword, and you would probably be carrying it. I mean, you might be carrying it for any number of reasons. Once weapons became guns, right, the idea that you were carrying it in a way that showed was threatening enough. That's the way it seems as if the way. But in either way, the Shia jurists were very, very clear that you had to have the weapon. And as I say, at least until the 19th century, Shia jurists were always saying you had to show it, right? You had to draw it out, right? And in the absence of that, there's no crime of banditry, right? It is not to say that you couldn't have anything else, but this sort of threat to the public order is through the threat to violence, right? That's the weapon, right? And it has to, the intention has to be to cause fear, right? I mean, that's the other thing that's insisted upon, right? You have to want to cause people to be afraid, right? I want to cause you fear. I want to get you scared. I don't want to change a system. I'm not looking to reform a system. I'm not looking to raise a legitimate grievance or reflect the fact that I'm hungry or whatever. And you have those kinds of public disturbances even in the past. I mean, obviously they take different contexts, but none of this counts because the intent of whatever you're doing to cause you to go out isn't to scare people, right? To scare ordinary people, right? And one thing that they were also really, really keen on was to say, don't say it's the folks upon whom you normally cast suspicion, right? Well, it would normally be men. It'd be normally men of this tribe. It would normally be men who kind of look like this. It would normally be men who, have this profession. And the pull was to get away from that. Look, we don't want to, and in that sense, it's broad, right? What we want is people who are actually threatening the public order. That's what this is supposed to be about. I don't care who you are. I don't care what your gender is, what your tribe is, what your profession is. If you're going out showing weapons with the intention of causing fear in people, that's enough. Interestingly enough, it's another thing that they were very concerned about, right? American law has conspiracy, and conspiracy, as Susan could tell you as well as I could, and say it as well, is this just this really broad doctrine that starts to create systems in which the immigrant from West Africa who has swallowed 100 condoms with heroin in them gets sentenced to 95 years in prison, the same prison sentence that some ringleader would get, because it's all part of the same conspiracy and we're all lumping everybody together. And this is a massive power that a modern state has, and the modern United States has through RICO and similar conspiracy sort of acts. And it's very interesting to see the ways in which the Shia jurists were very concerned about that. No, if you're helping the muharib, the person doing this, it doesn't count. The people we really want to fit within this really bad category are the ones actually drawing the weapons, not the person who gives them the weapon, not someone who's giving them food or water or even knowing what they're doing and supporting them in one way or the other. That may be bad, but this scriptural crime, and again, it's defined narrowly as Susan says, but this is really meant to deal with that, folks, because we're really worried about the state starting to go and grab everybody as being friends or supporters or of some sort or other of folks that are described this way. And then the one that the Shia jurists never resolved and kept going back and forth on is whether someone who wasn't actually a threat, but kind of looked, or didn't necessarily look like a threat. That is to say, they didn't cause fear among anybody because it looked relatively harmless. Whether or not that was enough, and the concern was, hey, wait a minute, they wanted to scare people. They showed weapons, right? They're the ones actually doing this. They're not just supporters. That should be enough, right? This is what they wanted to do. And then the other aspect, the other side was, yeah, but you really have to measure this by, does it create that kind of public disorder? And whether or not the public disorder this is not actually created because there's just no real threat. And how do we address that? As I say, obviously, you can't take any sort of set of principles from any sort of set of actors in a very different system and just plot them in. At the same time, these are neutral principles among people who don't like police and yet are sitting around trying to figure out, traditionally don't like them, are sitting around trying to figure out, well, okay, but at the same time, we don't want people scaring everybody in the middle of a city by showing a bunch of weapons and shouting about how they're going to take over the government or do whatever. We do need order, and how are we going to reach these balances? And they are attempting and struggling to find some set of neutral principles. So as I say, I thought it was a useful sort of exercise to go through and illuminate. I don't know if I'll draw the analogy any more strongly than that. I would invite readers of the work when it ultimately comes out to do that, and I'm certainly happy to talk about it. But that's sort of where I end my remarks. With thanks to all of you for listening at this hour.
Thank you so much, Professor Hamoudi. I know you being on the East Coast and everything going else on, yeah, you have a tight timeline to work with, and so I wanted to. With the permission of Professor Haskell, to direct a couple of questions at you and let you take your leave. And so, you talked about what acts. One of the things that the jurists were talking about was what acts are considered part of as causing corruption. And what I wanted to know is there any discussion about like who is causing the corruption? And of course, I'm thinking about, or who may be animating the corruption. I'm thinking about the insurrection that happened here. Like there's obviously, there were accusations that he was either it was the president himself or his attorneys that were, fomenting the fires, and that's what led to people charging the Capitol. So if where would that fall? Is there a discussion about, well, who's relying on what information to do this? And does it have to be, only those who are actually doing the physical harm, or those also that are, causing disinformation to be spread that leads to the physical rebellion that could come about?
Yeah, and that's a really good question, and it's one that I'm sort of looking into, because clearly the distinction that the Shia jurists were making that I was trying to identify was not between the inciter, which is where I'm understanding your question to come from, Sayed, and the person actually drawing the weapon. Because that's a much closer relationship, as opposed to, let's just sort of say, the person drawing the weapon and then a whole bunch of other people nearby, shouting support. In other words, there may be a difference of degree between, or at least the Shia jurists, let's just say the Shia jurists sort of identified a difference of degree between those two groups. And so the real question becomes, well, what about the inciter? And certainly rebellion law, which is very closely related, the baghi, which is very closely related to the ḥirāba, did very much ascribe, Shia jurisprudence certainly has ascribed a very close relationship for the one leading, if you will, all the way back to Ali ibn Abi Talib's first war, which I think in Sunni accounts is called the fitna, between Ali on one side and then the son-in-law of the Prophet on one side and the wife of the Prophet on the other side. And so, the attribution of blame, not necessarily directly to Aisha, but at least to Talha and Zubair, goes fairly high. And so my suspicion is that as I look more closely into this, that they will more closely tie incitement of some sort, although incitement might not be the right word in a less mass media sort of, but the leader of the person, even if they're not necessarily carrying the weapon themselves. But I will confess that my initial instinct from reviewing some of these texts leads me in that direction, but I'm too hesitant to draw that absolute conclusion until I read a little bit more. So
very good, thank you. And then in terms of intent to cause fear and terror, how is that intent established? Is it through the actual raising of the weapon, therefore this intent is clear, or is it in some other way? To say it again, like were there just discussions by jurists about what constitutes intent itself?
Right. I think intent goes into the internal mens rea. I mean, I do think they were, and I noticed one of the questions was about this. Well, you know, a lot of people could just be scared of, let's just say, I mean, irrational fears of African Americans, for example, in the United States. And I really think the Shia jurists were trying very hard to get away from that when they kept saying, don't focus on the identity of the perpetrator and deciding what causes or doesn't cause fear. Focus on the intent of the victim, the fear of the victim. Focus on the intent. Does the perpetrator seek to create fear? Right. And I think that they're thinking about it from the point of view of the weapon, not only just the weapon, but sort of the broader set of acts, if you will. They're trying to get away from it's men, it's women. I mean, that's usually what the biggest focus was, because I mean, of a sexist assumption that, you know, women just don't cause the same fear in people that men do. But at the same time, it does seem to me that what they're really focused on is the mens rea, that is to say, the intent of the perpetrator themselves. When you draw a weapon and then you're sort of threatening physical harm to others, then one draws from sort of that set of facts and circumstances what the perpetrator is intending. Whether or not someone has an irrational fear or doesn't have an irrational fear, I think is a separate question than whether or not one intends it. So
I see. So, I mean, recognizing, you know, the important point that you've made about not being too facile or being reductionist in the comparative sense. And so recognizing that, you know, if one were to think about the folks who charged the Capitol and they were to argue, well, our intent wasn't to cause fear, you know, we were doing this based on what we thought was a legitimate issue with the ways in which the elections occurred. And so, I mean, would that then would that serve as an exculpatory type of a consideration? Because the intent I mean, yes, there were some, I mean, of course there were some who were saying hang Mike Pence, or they were trying to find different, you know, Democrat Congress folks. But those that weren't, those that just thought to, you know, go in there as a sign of protest, and not intending to cause harm or fear, would they be lumped in with all these other folks, or would they might have an out because that wasn't what they were trying to do in the first place?
Right. Well, just to be clear, I mean, you can intend to cause fear and terror and have some ultimate political objective. That's what terrorism usually is, right? I mean, in other words, your goal is to scare the crap out of people in order to achieve something. And so I would think that if you went into and you already, I mean, you anticipated that with the way that you phrased the question. But if you were to walk into a Capitol building with highly dangerous weaponry and start saying hang so and so, I don't know how you could say you didn't have the intent to cause fear. Of course you did. Now, you may have said my ultimate motive was to hang so and so. It wasn't to scare. But I mean, the goal of that is to scare people, right? I mean, so you want to achieve your political achieve your political reform through scaring people. Now, if you were to say, well, what about someone who didn't have any weapons and sort of participates? Again, I think that the fact that it doesn't fit within a scriptural crime, and I think Susan made this point very aptly, the fact that it doesn't fit within a scriptural crime doesn't mean it's okay. The scriptural crimes, because they're crimes against God, are really meant to identify the worst of the worst, right? I mean, these are the folks that just, you know, and I do think that therefore there is a moral normative distinction that Shia jurisprudence identifies between the one pulling out the weapon saying, go get this person and hang them from a tree, who clearly is seeking to cause fear, whether or not they have some ultimate political objective or not. I don't doubt that they do. And someone who isn't doing that, right? I mean, I do think that the sense is that there's a normative distinction. And let me just say, I think American law also has that distinction. I mean, you can see that in the way these folks are being charged. Some for trespassing into a federal building, and then some for, you know, for rather lengthy jail sentences, which you don't get for trespassing into a federal building.
Yes, that's true. That's true. Thank you so much. Well, thank you for this fantastic, you know, insight. And while I want to respect your time and you know, the fact that you have to jump off. And so, I think there will be more to come, and look really forward to the ultimate paper that comes through, and looking forward to see how we can learn more, especially about Sharia jurisprudence and law when it comes to this important issue of ḥirāba and the ways in which we can learn and possibly procure some ideas when we also think about criminal justice issues here in the U.S. So, we really thank you for your time. I personally thank you for your time. And you never have to apologize for a child coming in, for one of your kids coming in and crashing the party. I mean, that's the world we live in now. And so it's completely understandable.
No, that's very kind and generous of you, and thanks to you, Sayed, and thanks to the whole audience. I mean, I thought some of the questions were really engaging, and I'm sorry, Susan, that I don't get to hear you answer some of these questions because I would really love to. But yeah, they're going to come crashing in again if I don't
Very
figure
good.
something out. So
Great. Well, thank you so much, and you have a great night.
Great, thank you. It was a pleasure and an honor.
Susan, can you hear me? You're on mute, and we have two screens of you, but that's okay. But as long as we can get you unmuted.
I'm going to stick with the small screen. Can you hear me?
Okay.
Well, I missed that wonderful discussion. Most of it, I don't know. My computer froze up. I do not trust it any longer. So now I'm on my phone, and it looks like I'm in San Francisco. I'm magic. I just went there.
Well, we have two screens of you. One says San Francisco, another has a background, so we get to enjoy.
Okay, well, here, I'm just going to shut this there.
So,
Okay.
so let me ask you. One of the questions that came through was, what would you say is the best way to bring Islamic or religious values to the U.S. criminal justice system? I mean, is there a way that you can, have a transfer of ideas in a realistic way?
Well, I think what we're doing right now is the way to do this, because there's, as you all know, so much bad publicity about Islam and Islamic values, and especially about Islamic criminal law. I think the best approach is to do a comparative approach and to pick particular issues and say, hey, we have something that we can learn here. This is another way of looking at these issues that all societies deal with. And if we can have an appreciation of the hundreds of years of scholarship that have gone into coming up with the solutions under Islamic law, then we can benefit. But I don't think that there's a way to just wholesale say, hey, we're going to take the Islamic values from criminal law and get people on board with that. I think we have to go issue by issue.
Sure. Thank you. Another question that we have is, how does the case that you make for the intersection of morality, justice, and criminal law apply to assigning systemic culpability? So how can it work in that regard when we think about a systemic issue that exists?
I think it works very well. I mean, we've had a very intense conversation in this country in the last year or so over police brutality and Black Lives Matter, and we've seen some horrific examples of the state using its power of force inappropriately. So I think that's a systemic problem, in my opinion. And so the confluence of morality, we don't think that these things should happen. Innocent people shouldn't be killed in the street by the actors of the state. So I also think that we're working on this as a society. We're having this discussion about accountability. Mm-hmm. So, I don't think that there's any justice without some kind of accountability. And so I think that all of these things weave together quite well when we're talking about systemic injustice.
Got it. Thank you. And a question from Ayanna Squires, who asks, why do you think the U.S. has not adopted a poverty defense?
I think because, well, that's a really good question. I think it comes down to the emphasis in our historical jurisprudence and culture on property rights. I mean, property rights are mentioned in the Constitution. They're one of the reasons that the country was founded was to protect the interests of the property classes. Mm-hmm. and we also don't have a tradition of thinking about rights as positive rights. We have the right to be free from things, but unlike in Europe and some other parts of the world, we don't have the idea that we have the right to things. So I discovered in law school that a huge portion of our laws really are more about protecting property rights than they are about protecting individual liberty. And positive rights basically don't exist. We have to pass legislation to implement any sort of social system that would support people, but it's not ingrained in our legal culture, and it's not something that we as a people have a historic basis for emphasizing.
I see. Now you said that certain European countries have the idea of positive rights. Did I understand that correctly?
Yes, and that's not something that I really looked into recently, but it is a cultural difference, that their concepts of the concept of rights would be more inclusive. The right to health care as a human right. If you look at the UN Declaration of Universal Human Rights, there are a lot of positive rights in there, and we seem to be resistant to that. We have a strong strain in our culture that is, I guess, a little bit like the Shias. We don't want a whole lot of government intervention and are a little suspect about positive rights, healthcare, food, housing, all of these things.
Okay, I see. And so, well, one reason for asking is that because a question came in from one of my students, Javier Rodriguez, who asked that, are there other non-Muslim majority countries, do you know of any that do have necessity as a defense, such as extreme poverty?
Okay, well, yes, we do have necessity as a defense. I didn't use a very good example of that. Yes, we do have necessity as a defense, but our judges have been very, very reluctant to use necessity as a defense when it comes to stealing out of poverty.
Mm-hmm.
In France, they have taken this idea, and it's gained a little bit of traction in some courts, where they are taking into consideration in charging somebody with theft. But no, it's not very popular. And like I said, but that doesn't mean that we don't have an underlying moral sense that it would be wrong to criminally punish somebody who was in fact stealing out of necessity. So like I said, it's a gap, and a lot of different things are overlapping here. But you know, it is something that is mentioned in the literature and has been thought about for a very long time. And I think it's a good time to start rethinking that at this point.
Thank you. One final question, and I'll let you go, which is that, you know, to what extent, you know, is there a way to reduce the reaction among Western secular jurists against a robust dialogue with legal traditions that are rooted in faith? And this comes from the former director of the Catholic Muslim Studies program and my colleague and friend, Scott C. Alexander.
Is there a resistance to talking about legal traditions that are rooted in faith? Yes, I mean, we definitely have a more secular way of looking at things, and can be suspicious of these different religious faiths. But I do know quite a few scholars who do look at canon law and different sorts of legal traditions, and any legal historian will be able to tell you that family law systems, courts of equity, there's a lot of influence from the canonical traditions in American law and in Western law in general. So yeah, when we're talking about Islamic law in particular, of course, there's going to be a lot more pushback. Mm-hmm. But, you know, people do look into the Catholic legal traditions and other faith-based traditions in doing research as well. So I have hope.
I see. Well, it's contribution like yours that can help bring the Islamic legal system into the discussion. So it's very much appreciated.